Hi, everybody. My name is Emily Sweeney. I'm a reporter at the Boston Globe, and I sit on the board of the New England First Amendment Coalition. I'm also president of the New England Society of News Editors. And today I'm here with Mark Freel. Mark is a partner at Locke Lord in Providence, and he's served as a lead counsel in numerous cases involving constitutional and civil rights, including First Amendment rights. And he's going to give us an overview of public records law in Rhode Island. So Mark, thank you so much for doing this.
My pleasure. Thank you for having me. And I hope that I can answer any questions or provide some valuable information. For just a little bit of background, I was just telling Emily that I have a brief and very ancient at this point background in the journalism profession. I worked as a reporter at two different daily newspapers in New England, one in New Hampshire and one in Connecticut, a long time ago, and then decided for good or bad to go to law school. And so now here I am, and it's too late for another career change. So during my time as a lawyer in Rhode Island, but I'm also at a national firm, I've handled a lot of cases through the Rhode Island ACLU raising First Amendment issues. And I've also been on a lot of matters on both sides for what we here call APRA, or the Access to Public Records Act, which is a statute in Rhode Island, similar to FOIA, which many of you are probably familiar with, and probably similar to state laws in a lot of other states. And in the last, 10 years or so, I've been on both sides of APRA matters. I've represented media outlets in pursuit of APRA requests and claims. And I also currently represent a couple of Rhode Island state departments in responding to APRA requests. So I think I have a nice, mixture of perspective of the two different sides, and we'll try to give you both sides of that as we go through this presentation. So there is an entire section of the Rhode Island general laws devoted to what we call APRA, and this is sort of the stated legislative purpose behind that act, which is, sort of high level and constitutional in its terms. But the whole point is that it's a straddle between the public's right to know on the one hand and some rights of privacy and confidentiality on the other hand, and an attempt to sort of find some appropriate middle ground between those competing interests. So here are some of the key questions that come up. So first is, what is a public body? And that's very broadly defined in Rhode Island law. So really any kind of entity or quasi-public entity that exercises any governmental functions is going to be covered, and including local government as well. Public record is also very broadly defined, includes all kinds of, what we now as lawyers call ESI, electronically stored information, as well as paper documents and other communications, emails. And, I've been a litigator now for over 30 years, and the world has greatly changed in terms of how we now harvest and collect and produce documents through electronic search functions and capabilities. And you see that really happening now on the APRA side as well. Then there are the timing requirements, and I'll get into those in a little bit more detail at the end of this presentation. And then what documents are exempt from production, and I want to walk through some of that. The one thing that I didn't put in this outline that occurred to me to get into a little bit, given this audience, is how do you write an APRA request, and what are the key things you want to do and do well to make sure that you're maximizing your chances of recovery. The media clients that I have assisted in recent years, often I don't write their original requests. Often the reporters write them themselves. And then by the time they get me involved, it's after they've already gotten some sort of objection or opposition from a state or local agency. And then I'm looking at a set of requests that have already been written. And a lot of times they're written very well. Reporters, as we all know, are good writers. I used to write that way before I started writing as a lawyer. But as a lawyer, I really focus a lot on the precision that we try to achieve in what we call document requests in litigation. So I think there are some key things that I see sometimes people miss that are just worth thinking about. I think, first of all, if you're writing a request under our law here in Rhode Island, you want to make clear that your request is an APRA request. There aren't a lot of magic words as long as you say that. If you don't, the receiving party would have the right to treat it as just an informal request, and they might respond, but then you're left without the power of the statute behind you. So first and foremost, make sure it's clear that you're making your request under the statute. I also think date ranges are important, so that you've established some sort of a time field covered by your request. And then, since so much these days is in email, you want to think about how you want to define the nature of the communications, who they're to, who they're from, and maybe even a short list of numbered requests so that you cover the field adequately. So give some thought to how you want to draft and make clear what you're asking for. When the public body receives your request, the first thing they're going to think about, other than timing, and I'll come back to that, as I said, is how big and how broad is this? How are we going to search for this? And then what things do we think may be exempt from this request? One of the most common exemptions, thinking like a lawyer, is attorney-client privilege, to the extent that the public body that you're requesting records from has consulted with their counsel or has engaged counsel to assist them in some matter. Anything between them and their lawyer that relates to legal advice is going to be exempt from production. And that's true in litigation in my world all the time as well. There's also a major statutory exemption for personal and individually identifiable information, social security numbers, dates of birth, passport numbers, all those kinds of things. And there's a long definition there, and there's some federal law under FOIA that kind of backs all that up. And we have data and privacy lawyers in my firm who can talk, who know that stuff even more detailed than I do. But these are the kinds of things you need to think about. Actually, one case I worked on for a local media outlet here in Providence had to do with the relevance of dates of birth to voter registration records, because sometimes that's the only way to distinguish between multiple John Smiths and to know whether or not there's duplication in voting records. So sometimes there are personal and individually identifiable data points that are arguable. That case went up to the Superior Court here in Rhode Island. It was ultimately resolved by agreement. But a lot of times that stuff is pretty objective and pretty clear. Then there's trade secrets or confidential or financial information received from a third party. And the important thing there is the expenditure of public funds by a municipality or by a state is typically fair game and public information. But sometimes if public bodies receive certain kinds of confidential or financial information from third parties, there can be circumstances in which it's appropriate to withhold that under APRA, at least for some period of time. Sometimes while a deal is being negotiated, maybe after the deal is done, it's no longer appropriate. But this is another common exception that I see applied. Another one that I see come up when I'm on the public body side is statements of strategy or negotiation with respect to public transactions. I know that probably sounds pretty vague, but to give you an example, one of the public clients we represent is frequently involved in the sale of public lands. If we're in the middle of price negotiations with a third-party developer who may be buying a piece of land from the public body, disclosing price negotiations while they're ongoing is not going to work, because, you know, you can't negotiate in public. Once the transaction is closed, however, this statutory exception is quite clear that that it no longer applies. So there are some exceptions there. Also, drafts and notes and impressions in work product, there's a pretty big exception for that. So if a public body and a third party have been exchanging red line drafts of a document, you're going to get the final version, but you may not, without a fight anyway, get the drafts, the red line drafts back and forth. Before I get to the last bullet point here, I'll just say that these are only a few of the statutory exemptions to APRA listed in the statute. There is a long list of them going all the way from A to AA. So that's 27 if by my count. There are, you know, things that have to do with child custody and pensions, tax returns, all kinds of other things that are a little more arcane, criminal records in certain circumstances. And I didn't think it was worth me getting into detail all those records, but you should be aware credit card numbers is another one. So there's a really long list of other exemptions, but I've covered the ones that I think are most important. My last bullet point on this slide is about one that isn't in the statute, but which the Attorney General here in Rhode Island and some trial courts in Rhode Island have decided in their infinite wisdom deserves to be added. And it's one called the deliberative process privilege, which sounds very vague and big and undefined to me as a lawyer. It really has its origin in FOIA, the Freedom of Information Act. So there is a legal basis for it. And as I said, the Attorney General in Rhode Island has adopted it and recognized it. And so have some trial courts in Rhode Island and have said that it is part of APRA, even though it's not called out by name in APRA. And it is an exemption that allows a public body to withhold what is called in one of the court decisions, agency give and take, deliberations that go on within an entity. Now, the courts are clear that it has to precede a decision. So it can't just be talking in a vacuum. It has to be back and forth within the agency about a specific decision that is being made. I see a lot of pros and cons on this, having dealt with it on both sides. I think the biggest risk is that if public bodies are overly aggressive about asserting it, it runs the risk of being the exception that eats up the whole rule and ends up being really contrary to the point of the whole statute, which is to create transparency in government deliberations. On the other hand, I do know, and I have seen public bodies choose selected areas where it is appropriate, and I've seen it upheld by the Attorney General here in Rhode Island. So it does exist, and it's one that everyone has to deal with. So I just wanted to call that out so that people are aware of it in case it comes up in any time when somebody might be pursuing a request to a local body here in Rhode Island.
And actually, sorry to interrupt.
No, please.
We have two questions pertaining to the exemptions.
Okay, let's do that.
Okay. So one person has a question. Does attorney-client privilege apply to state agencies? For instance, a state agency hires a law firm for an audit. Can the agency cite attorney-client privilege to exempt records?
Well, with respect to an audit, I think I would have to know a little bit more about the audit in order to draw any clear lines around what would be privileged and what wouldn't be privileged. But in general, absolutely, state agencies have the right to engage outside counsel. Many state agencies also have their own internal in-house counsel. There's general counsel at most of the larger state agencies in Rhode Island. But they also have the right to engage outside counsel. And if state agencies are seeking advice from their outside lawyers on legal matters, that is absolutely privileged. As with any privilege, covering communications between a lawyer and a client, it has to be about legal advice or to assist in giving legal advice. It can't be business related advice. And when it comes to audits or internal investigations, the facts themselves are not covered by the privilege, only the communications between lawyer and client and the legal advice that goes along with those communications. So you have to know what the nature of the engagement and the nature of the relationship is in order to really draw clear boundaries. But the simple answer to the question is absolutely, state agencies can communicate with outside counsel for legal advice. And when they do, there is a privilege there.
Okay, and the questions are pouring in now. So we have 3 more questions.
Okay.
These deal with exemptions as well. Different person asked, if a consultant provides information to a public agency on a matter involving public funds and they deny a request based on attorney-client privilege, is there any recourse on appeal? If so, on what basis?
Well, I would say that the basis would be that a consultant who's a non-lawyer consultant, a financial consultant, an engineering consultant, an environmental consultant, they're not lawyers. And the attorney-client privilege only applies to the relationship between clients and lawyers. In fact, the way this APRA exception is worded in the APRA statute in Rhode Island is records related to an attorney-client relationship. It also adds doctor-patient, which I didn't include here in the presentation, but that's also included. But it really talks about the attorney-client relationship. So I would say that non-attorney consultants, financial, engineering, and others shouldn't be included in attorney-client privilege. And if that's the basis on which they're withheld, I think you would have successful recourse first to our Attorney General, and I'll get to the appeal options when we get to the end, in order to challenge that exemption.
And here's the last exemption question that we have right now, asking, will we be covering Exemption M in this webinar? And they write, electronic communications of elected officials with constituents / official capacity. How would you word a request to get emails of elected officials to prove rolling quorum OMA violations?
Okay, so I'm aware of Exemption M, and I also am aware of rolling quorum. And for those who don't know what that means, is public bodies aren't supposed to conduct deliberations outside of a duly noticed open meeting. An open meeting law and APRA law do work in conjunction a lot of times. And so it's okay for one member of a board or commission or agency to talk to another single member of a board or agency about a matter that's going to be pending before them, because that's not a public meeting. It's just 2 people talking. But what can happen sometimes is if a single member, maybe sometimes a chairperson, although not necessarily always, of a public body, has a series of communications with all the other board members in a series of separate communications. So in effect, that becomes a deliberation on the pending matter outside of or before the public meeting. It can be deemed a rolling quorum, even though they weren't all present at the same single moment in time, and it can be an open meetings violation. The question on Exemption M is a good one. Exemption M, which I've seen invoked occasionally, but not a lot, but maybe this is one area where it could come up, is and I'll read it because it's short. It's correspondence of or to elected officials with or relating to those they represent, and correspondence of or to elected officials in their official capacities. I don't really know what the legislative purpose behind this is. If a state representative is communicating with his or her constituencies or constituents about a matter of public concern, I don't know why that should be excluded, but the exemption is there, and I've seen it invoked in that scenario before. However, my instinct tells me, without ever having seen a written decision on this, there may be one, I just haven't seen it, that if you were making an open meetings challenge, and if the basis for your open meetings challenge was that there had been a rolling quorum kind of situation where the discussion to be held at a public duly noticed meeting was happening outside the meeting through a series of individual emails between and among board members in advance of the meeting in order to sort of decide the meeting in advance, I think you'd have a good argument that that shouldn't be covered by Exemption M, because it's inconsistent with the purpose of another statutory requirement. So if anyone listening has had direct experience with that and wants to send in something to Emily, I'd be interested to hear it. But I think that's an interesting juxtaposition of two separate statutory provisions. But my sense is that that exemption wouldn't allow a public body to engage in an impermissible rolling quorum outside a public meeting and then insulate it all from public disclosure. I don't think the Attorney General would permit that. So I'll just go to these last little thoughts here. So quickly, the original response time in the statute when an APRA request comes in is 10 business days, which in effect is 2 weeks. Unless the public body can demonstrate some need for 20 additional business days. Now, I'll tell you, all the public body has to do is send a letter that says they're really busy and they're buried and it's a really big request, et cetera, et cetera. And by the time a requesting party like one of you perhaps gets that letter, there probably isn't much you can do about it other than maybe appeal to somebody higher up in that public body. I will say that having been involved on the public side of APRA requests, I am sympathetic that there are sometimes people in the community who get really focused on some issue that they care about, and who can really barrage a public entity over a period of time with a high number of really broad and big requests. So sometimes responding to these is time consuming and can be burdensome for smaller agencies or municipalities. But the public body typically has 2 calendar weeks and can avail themselves of an additional 20 business days. And depending upon the size and volume of a request, the public body may or may not avail themselves of that extra time. There is a clear section in the statute which says that if there are what's called reasonably segregable or segregatable parts of a document that are not subject to an exemption, such that they can be redacted and other parts of the document can still be disclosed, that should happen. So if you're finding that public bodies are withholding entire documents under circumstances that lead you to believe there's only one small part of that that is subject to their claim of exemption, that's a pushback issue. I've seen the Attorney General uphold and insist upon compliance with that. And so that's an area where perhaps some pushback is worthy of consideration. Public bodies can impose some limited costs. It's $15 an hour after the first hour, plus any actual costs incurred. You know, back in the older days, this was all done on paper, and there's a photocopying charge that the statute says they can pass on to you. But now, of course, that rarely happens because now these are almost all done by electronic searches and electronically produced. Sometimes if an outside vendor is engaged to conduct the search, because a lot of state agencies will use some sort of outside hosting agency, and then that hosting entity will conduct the electronic search. That's a one-time cost that can be passed on. The public body is supposed to give notice of that and say, hey, we're going to impose costs on you. So before we do all this work, here's our good faith estimate of what it's going to cost. Sometimes I've seen requesting parties see that and back off. They can go to the Attorney General over that if they think it's unfair. But there is a section in the statute that allows some reasonable cost sharing. And last is, what do you do if you're not happy? The first appeal is supposed to be to what's called the Chief Administrative Officer of the agency or body to whom you've directed the request. Every public body, local or state, is supposed to have named somebody who's their chief APRA officer. But in the cover letter that goes out from those bodies when they produce, they're supposed to tell you who you can appeal to within their agency. Now, sometimes that may be viewed as a wasted step because there may be a perception that you're going to get the same answer from them, but it's a step you ought to take. Then you can go to the Attorney General. Then you can go to court. Now, you can go to court right away if you want. The statute allows that. But here in Rhode Island, I find that the much more common practice is to go to the Attorney General first. It's faster. I think it's more efficient, less costly. And I think the Attorney General here takes those requests pretty seriously. Not to say that they're always going to rule in the media outlets or the requesting party's favor, but I do think they take those seriously. So I think you're better off going to the Attorney General first. They can initiate suit if they want. They usually will not unless they find that there's some really willful, wrongful, or reckless behavior, that somebody has just completely disregarded the law without a good faith basis. But then it can go on to court, and then the court can impose some fines if they find reckless, willful, or knowing behavior. So those are that's sort of the triage of appeal options that you'd face here in Rhode Island. So that's kind of the issues I plan to talk about. Here's who I am and where I am, should anybody want, but in the time we have remaining, and I'm happy to stick around for a few extra minutes, I'm happy to answer any other questions.
Yeah, so we have two questions here. One is, how is official capacity of elected officials defined in APRA?
Well, APRA defines what a public body is, but doesn't necessarily define the individuals within a public body. But you would typically direct your APRA request to a public body by directing it to the person that public body has designated on the Secretary of State website as that body's APRA official. So you direct the request to the Department of XYZ by directing it to whoever they have designated online as their representative. Each public body is required by the statute to establish written procedures regarding APRA requests, and they are supposed to designate who their public records officer is.
Okay, and then the official capacity phrase?
Well, official capacity is a phrase I see used more in other legal contexts to define whether somebody has been sued or a claim has been made about somebody's on-the-job behavior versus their personal conduct. And you'll often see that when lawsuits are filed and people are named care is taken to point out that people are named in their official capacity as opposed to being sued individually, which accomplishes several things, not the least of which is that those people don't have to report that they've been sued personally. But I don't know that that distinction should matter a lot in an APRA request, unless maybe I'm thinking here that if you were to request communications between a specific public official and on a specific topic or to and from another person, and then if the public body were to come back and assert a privacy or personal exemption that I mentioned earlier and say, well, no, that person was only communicating with that other person in their personal capacity and not in an official capacity, then I think you would want to consider whether or not you would challenge that by an appeal to the chief administrative officer of that body or to the attorney general. Because my guess would be is if you're directing your request targeted to a matter of public business, that's probably not going to be a good exemption. But it would really depend on the subject of your request.
Want to do one more question?
No, absolutely. I'm fine.
Here's an interesting one. What if an APRA request is denied by a public agency claiming that the work product exemption they're producing is, quote, ongoing work related to audits of the state's financial statements and federal programs, unquote?
Yeah. If they're in the middle of discussions with either outside or internal accountants, or they're in the middle of an audit and there's work papers or drafts, there could be an appropriate objection there. But in the end, you'd be entitled to whatever the final documentation is. I think, to be honest with you, without having people sit and watch me look at something, which I know is not very exciting, I'd have to say on that one, it kind of depends, and I'd need to know a little bit more facts before I could give any kind of a final answer. Tax returns, which public bodies typically are not filing in that capacity. I'd have to say it really would depend. But I think in the end of the day, after you would exclude any ongoing audit or deliberative process privilege and drafts and work product, the ultimate resolution of whatever the issue is a public document.
Mm-hmm. Well, thank you so much. This was a great session. I know I learned a lot, and thank you for answering all these questions that we got. I want to thank everybody for joining us today. I want to thank the New England chapter of the Society of Professional Journalists. They co-sponsored this webinar along with NEFAC, the New England First Amendment Coalition. And thank you, everybody who joined us today. And Mark, thank you so much.
Thank you. My pleasure. I enjoyed it.
All right. Take care.
Thank you very much, everybody.